July 16, 2022, the High Court, exercising a revisionary power under Section 102 of the Juvenile Justice Care and Protection of Children Act 2015, tested the decision of the Board of the Children's Court with respect to its legality and its proprietary only, which the Supreme Court observed quite keenly. So, clarifying that the task of preliminary assessment under Section 15 of the Act 2015 is a delicate task with requirement of expertise, and it has its own implications with regards to the trial of the case. Therefore, the division bench of Justice Dinesh Maheshwari and Justice Vikram Nath said that without much elaboration, we leave it open for the central government and the National Commission of Protection of Children's Rights and the State Commission of Protection of Children's Rights to consider issuing guidelines or directions in this regard, which may assist and facilitate the board in making the preliminary assessment under Section 15 of the Act 2015. So, facts relevant for adjudication of the present appeal were that in an institution located in Gurugram, a class 11th to uh, a class student by the name Prince was found in the toilet with his throat slit open, and he was found at about 8:30 a.m. So he was rushed to the hospital but was declared dead. Initially, the state police arrested three people: a driver of the school vehicle, two officials of the school uh, who were suspicious enough to be arrested, but later they were released on bail. The CBI interrogated a class 11 student by the name of Bholu from the same institution on two to three occasions and then arrested him on November 7, 2017. Later, the social investigation report was prepared under Section 13 by the legal probation officer. Section 15 of the Act mandates that where a child in conflict with law has committed a heinous offense and is above the age of 16, the board would take a preliminary assessment and pass appropriate orders in accordance with the provisions of subsection 3 of section 18 of the Act. In this very case, both the conditions required under section 15 of the Act were fulfilled. As such, the board undertook the exercise of making the preliminary assessment. The board called for a report from an expert psychologist and proceeded to pass an order holding that there was a need of trial of respondent as an adult, and accordingly directed the transfer of papers to the children's court. Aggrieved by the judgment of the children's court, the respondent preferred a criminal revision under section 102 before the high court, so it was allowed. It is this order passed by the High Court which is assailed by the instant appeals. The court noted that the preparation of a social investigation report is a statutory requirement for every child in conflict with law. It is to be prepared by the probation officer or any other agency as may be directed by the board. The order of preliminary assessment decides whether the child in conflict with law falling in the age bracket of 18 to 16 to 18 years and having committed a heinous offense is to be tried as an adult by the children's court or by the board itself, treating him to be a child. The bench had the opinion that the purpose of the act and its legislative intent, particularly to ensure that the protection of the best interest of the child, was the primary course, and the expression may be in the provision regarding to section 15 clause 1, and thereof the requirement of taking assistance of experienced psychologists or psychosocial workers or other experts would operate as mandatory in nature unless the board itself comprises of at least one member who is a practitioner with a child child psychology or child psychiatry. The power to carry out the preliminary assessment rests with the board and the children's court. This court cannot dwell upon the exercise of preliminary assessment. This court would only examine as to whether the preliminary assessment has been carried out as required under law or not. So, by furthering this statement, it has also been noted that the Act or the model rules do not lay down any guidelines of our framework to facilitate the board in making a proper assessment on the relevant topics or aspects. The only liberty and freedom that has been given to the board is to obtain assistance of an expert psychologist or a psychiatrician, uh, or a psychiatric worker, or any other related practitioner of mental sciences. The social aspect of it is really important. So the Supreme Court held that there was denial of adequate opportunities to the respondent. The list of documents, copies of the statement, uh, and the relevant documents were not provided to the respondent, and wasn't clear violation of Rule 10, Clause 5 of the Model Rules, as the Supreme Court noted. In the light of the aforesaid findings, the court dismissed the appeals. So that's my analysis. Thank you.